Now, I've been talking about this for nearly a half a century, and I didn't think too much of myself to even consider that I was the one that came up with this, what I'm about to read to you. And that's where we get to conspiracy against rights under the color of law because you're living under the color of law. And if you go through all my videos, you'll understand. Okay, but living under the color of law refers to government officials or individuals acting with the appearance of legal authority, even if it's exceeding it, to deprive someone of rights as detailed in Federal Law 18 U.S.C. 242. While The Color of Law, A Forgotten History by Richard Rothstein describes how the U.S. housing policies deliberately created racial segregation, making color of law a crucial concept for understanding systematic inequality and discriminatory practices. It's about abuse of power under the guise of legality, affecting rights, housing, and economic opportunity. Understanding the color of law. Definition. An act done under the color of law means an official uses their position or pretends to use it to violate someone's constitutional rights, even if that action itself is illegal or outside their jurisdiction. Who's involved? This applies to federal, state, and local authorities, police, judges, mayors, and even private entities like security guards or nursing home owners acting in official capacity. Example, unlawful searches, excessive force, false arrest, or denying housing services because of race, all done while wearing a badge or claiming authority. Like a lot of people, happened to me, got arrested, cops, jump out boys, jumped out, wanted to know where I was going, wanted to check my pockets, wanted to ID me, and I asked why, what's going on, etc., etc. They accused me of resisting arrest, assaulted me, and they got upset because I said they were acting under the color of law. You know, they arrested me because their feelings got hurt because I was upset because they violated the stop and frisk law. You know, it was a Brady violation. You know, stop and frisk, the legal requirements are that are pat downs to see if they have weapons. You know, something that you can, but they have no legal authority to go through your pockets, your wallet, tell you to take off your shoes. No, it's a pat down. That's all it is. So they were acting under the color of law. They were mad because I was instructing them how they were violating my constitutional rights, their constitutional duties. In my younger days, I got the crap beat out of me by a few cops for questioning their authority and citing my constitutional rights. What are you, a constitutionalist? Yes, aren't we all? You know, I took a pledge of allegiance, and that allegiance was to we the people. The people you took an oath to serve and protect, and I'm one of them. And that'd get your ass kicked a whole lot. Back then, you got your ass kicked for refusing to call a cop officer. Act like one and I'll call you one. You don't look like Serpico to me. Serpico wouldn't do that. Okay, examples. Okay. Okay, The Color of Law, the book. Oh yeah, I always wanted to read that. I never got around to it. Core argument. Author Richard Rothstein argues that U.S. residential segregation wasn't accidental, but a result of deliberate federal, state, and local government policies. That also violates the rule of law. I mean, that's pretty simple. That violates the rule of law. You know, in a nation of laws, that is the law of the land, the United States Constitution. And any law repugnant to that carries no weight, said the U.S. Supreme Court through Thurgood Marshall. Court argument, government actions. These policies include public housing projects built in segregated areas, FHA-backed mortgages subsidized for white families in the suburbs while denying black families similar opportunities, zoning laws, and other measures that enforce racial separation, redlining. My family moved into a neighborhood. We caught a whole lot of hell because of redlining. It was our fault the government made redlining, and because we moved into a white neighborhood, all of a sudden their property values went down. But that was just a scheme to get them to sell their houses under market value, and then they sold to minorities at over the market value. You know, you want to live in this neighborhood, you got to pay extra. You know, we got better schools, because not a whole lot of money went to schools in minority neighborhoods. You know, they were understaffed, underfunded, and not minority neighborhoods weren't. So it was, you know, worked out well for the rich. You know, bankers, realtors, you know, and considering the fact that, you know, these people, through their campaign contributions, basically bribed your public servants to make laws in their favor, which is illegal because all laws must be created in the public interest. All public servants are there to serve the public interest. That's required by the oath. And, you know, the penalties for violating the oath, right? All right, so you're back to living under the color of law, and that starts with nobody living up to the oath, you know. And I told you the penalties for that. Living with the legacy, the concept in the book highlight how government actions, even seemingly neutral ones, have profound lasting effects on racial equality. Understanding color of law helps explain ongoing segregation and inequality, prompting calls for policies that actively reverse these historical harms. Well, that's pretty easy because look up legal obligations to do what's in the public interest. I did a video on that. And every public servant, lawmakers are legally required to make laws that are in the public interest, laws that serve the greater good, the needs of the many, not the greed of the few. That's what the whole Constitution, that's what the Constitution is supposed to be based on, serving the needs of the many. Years ago, when I used to talk about it indiscreetly, people would call me a socialist, a communist, a liberal, because I would speak on, you know, in my own terms, you know, where it says in the Declaration of Independence that all are created equal, endowed by their Creator, with certain inalienable rights. Amongst these are life, liberty, and pursuit of happiness. And I always question about that not happening. It still hasn't happened almost 250 years later. You know, as a man, I've been waiting all my life. As a country, I think you can say the same. Okay. Hold on 1 second. Okay, operating under the color of law refers to actions taken by government officials who is using their actual or apparent authority to violate an individual's civil rights. And you see that happening on a daily basis from the police, to the president. And right now, the president isn't doing anything different what the police have done to you. You get mad and you hurt their feelings. What do? They come after you. And if you go after them legally, oh my goodness, everybody comes after you. All of a sudden, you're the bad guy. For citing your constitutional rights, their constitutional duties. As a citizen, I think it's all our civil-minded duty to live up to the Pledge of Allegiance. But we can't legally be held accountable to that, but all public servants took the oath to that, so they can all be held legally accountable for not doing that. That's called deprivation of rights. Remember, the Constitution and everything within are your constitutional rights, your birthrights as a U.S. citizen, which makes that their constitutional duty, their legal obligation. So operating under the color of law refers to actions taken by government officials who is using their actual or apparent authority to violate individual civil rights. It applies even if the official's specific actions were not legally authorized by law, so as long as they were done while purporting an act in an official capacity. Definition and context. The term is a crucial concept in the U.S. civil rights law and is primarily addressed in two key federal statutes. 18 U.S. 242, this makes it a federal crime for any person acting under the color of law to willfully deprive another person of rights protected by the U.S. Constitution. 42 U.S.C. 1983, this statute allows individuals to file civil suits against state and local government officials for actions that violate their constitutional rights. The essence of this concept is that the official's position of authority itself provides the color of appearance of legality, making their actions attributable to the government entity they represent. Who is covered? The color of law applies to a wide range of government officials, not just law enforcement. This can include police officers and prison guards, judges and prosecutors, mayors and city council members, care providers in public health facilities, private individuals who act in concert with government officials. Common violations generally involve abuse of power and can include both actions with bounds of unlawful authority and those that exceed it. Example, investigated by the FBI or the Department of Justice include uses of excessive force, false arrest, or fabrication of evidence. I was just talking to a young lady about a conspiracy against rights complaint. She's filing a conspiracy against right complaint. I told her where to find the complaint form. Just type in conspiracy against right complaint form, and it takes you to the FBI, the Department of Justice, and a few other government agencies that have civil rights divisions. And she asked which one, and I told her, I'll go through all of them and file a complaint with every civil rights division there is with every agency. And not just that, with the ARDC, file with the Judicial Inquiry Board, etc., etc., etc. She said she did, but they turned her down, and I told her you have to use the right language in order. See, you have to know the exact laws they're violating before they'll even consider. See, they know these laws are being broken, but if you don't know them, they're not going to do nothing about it because you ain't said nothing about it. So I gave her a whole lot to say about a whole lot. Actually, it's only 3 paragraphs long, and she's handling several different cases, different areas, different courts. But it's a win-win situation for her, as she sees it. But she knows the law. Okay, use of excessive force, false arrest, or fabrication of evidence. That's when if you get arrested and once you prove no probable cause for arrest, so they throw the case out. A case should be brought up against the cop for false arrest. Because for the most part, you got arrested for, not jumping through the hoops they demand you jump through. When they yell, you're supposed to say yes sir, no sir. Look at them, but don't look them in the eye. Look away. Don't get loud. Regardless of how they treat you, treat them with respect and the dignity they deserve because they're out there protecting. They want to get home safe. Right? Deprivation of medical care for those in custody. When the cops threatened to arrest me on a Karen call, and I said I would go, and there was no way what I was accused of I could have done. So I said, great. I said, you can take me to the hospital because I need medical care. I need my knees fixed, my wrists fixed, my neck, my back, get there, do the MRIs, and get all this fixed. And but yeah, while you're in custody, it's mandatory medical care. Look up constitutional rights of prisoners, constitutional rights. Just put a prisoner's constitutional rights. Says you have right to adequate medical care, housing, food, sleeping accommodations, clothing. That's an easy way to cure a lot of that BS that's going on in prison because that's the law for every state, Discrimination, that's easy. Penalties for criminal conviction can range from fines and imprisonment to life. Imprisonment to life in prison or death penalty if death or seriously bodily injury results from the violation. Federal Civil Rights Statutes, FBI. So there's, okay, a lot of places you can look up. I went to the FBI and they heard me out. They forwarded to the Department of Justice, and I'm still waiting on their response. Over 30 years waiting on their response. $30. Okay, deprivation of rights under the color of law. Oh yes, I was telling the young lady, she said she filed a complaint of deprivation of rights, but that was only on her attorney. But I explained to her when she files deprivation of rights on her attorney, she has to file deprivation of rights on the opposing party and the judge as well because it's mandatory to report misconduct. She reported her attorney for multiple violations of the rules of professional conduct. But they will always let that slide through. But if you mention that the judge and the state's attorney or any the other opposing party didn't cite your attorney for misconduct, reporting misconduct is mandatory in both the rules of professional conduct and the code of judicial conduct, and failure to report is misconduct. So the only way her lawyer can deprive her of her constitutional right of effective assistance of counsel was that the opposing party and the judge allowed them to violate the rule of professional conduct. These are the laws within a court of law. They are all legally supposed to be like watchdogs, waiting for somebody to screw up just so they could jump on them. You expect perfection. Zero. You want full accountability, and so far you're getting zero accountability. So I told her, so when you cited, they're not going to, I says, it's bad enough they're all working together. And they're adding to this conspiracy against rights. Because she clearly proved deprivation of rights, but she only cited her attorney. She didn't say, hey, the opposing party was in on it, the judge was in on it, because there's no way he could have got away with what he got away with if the judge and the opposing party didn't allow it, because the rules clearly say this is misconduct. Reporting misconduct is mandatory. Nobody reported misconduct, so everybody's guilty of misconduct for failure to report misconduct on everybody. The opposing party, the judge, and including themselves, because reporting misconduct is mandatory, even if they themselves. So if, to stay out of trouble, if they caught it before somebody else did, and they report it and vindicate that action, then I could understand. But this happens every day at every court, okay? So all you need to do is look up the rules of professional conduct, and then look up the rules of professional conduct complaint form, print those out, and you'll find out what this young lady found out. But remember, you got to cite everybody for deprivation of rights, and because they acted together, that evolved into conspiracy against rights under the color of law, which is illegal. Illegal. Totally illegal. Okay, remember, if somebody died, they could get the death penalty. Look at that. Whoa. Penalties for a criminal conviction can range from fines and imprisonment to life imprisonment, or the death penalty if death or seriously bodily injury results from the violation. Like there was some state's attorney, I forgot what state, was trying to overturn a wrongful conviction. And that's their job. It says so in Rule 3.8, Special Responsibilities of Prosecutor. If evidence presented that a prosecution of a wrongful prosecution, is their job to exonerate it. Exonerate that person. Seek all the legal remedies to, exonerate that person. And they put a stay, because I think there was a stay in execution, and the Supreme Court said no. But see, they're supposed to do that so the state's attorney can do their job. In the interest of justice, justice was supposed to be served. Justice wasn't served, and the legal remedy was turning the state's attorney and telling him. Well, I think it was too late for it to get to the Supreme Court, U.S. Supreme Court. I think the state allowed the execution. Stop. So not all state's attorneys are bad, because this person was literally living up to the oath. I bet you a lot of people came down on him, but, doing their job, if you look at their job descriptions, it's rare that they live up to those job descriptions. I mean, it's required by the oath. That's behind the oath. The rule of professional conduct and the code of judicial conduct. That's what gives you effective assistance of counsel, and that cuts every which way it swings, because once you prove ineffective assistance of counsel on your attorney, that proves the ineffectiveness of the court, because reporting misconduct is mandatory. Nobody reported misconduct, thus creating a case of misconduct on everybody involved, and that's where it evolves into a conspiracy. When I first wrote this back in '89, I didn't know how this existed. It was just laws I threw together, and I used a conspiracy of deprivation of rights under the color of law. It's just throwing a whole bunch of legal terms together, and that's just what I do. I put a bunch of words together, and they're just a bunch of legal terms. See? Conspiracy against rights under the color of law. The judge failed to report my counsel and the opposing party for multiple counts of misconduct and themselves for judicial misconduct. The opposing party failed to report the judge for judicial misconduct, my counsel for ineffective assistance of counsel, and themselves for misconduct. My counsel failed to report the judge for judicial misconduct, the opposing party for misconduct, and themselves for ineffective assistance of counsel. Reporting misconduct is mandatory in both the rules of professional conduct and the code of judicial conduct. Failure to report misconduct is misconduct, as is a failure to enforce one's constitutional duties as prescribed in the rules and the codes. The lack of the requirements of the Sixth Amendment of the U.S. Constitution, which is effective assistance of counsel, is beyond unethical. The lack of effective assistance of counsel doesn't allow for a fair trial, which shows due process didn't exist. A deprivation of rights in its entirety. It clearly shows the judge and attorneys in my case committed a conspiracy against rights under color of law, which is prohibited. The willful deprivation of rights lacks the privileges of immunities under the color of law. Conspiracies to injure, oppress, threaten, or intimidate any person in the free exercise and enjoyment of any right or privilege secured by the Constitution and laws of the United States. I trust you will live up to the oath, show competence, diligence, in expediting litigation, as I have meritorious claims and contentions, so I strongly stress reporting professional misconduct and maintaining the integrity of the profession. I trust communications will be made for ethical violations and every penalty will be imposed. In the public interest as trustees, this is how to maintain the public trust. Failure to do so will add to this conspiracy against rights under the color of law. An interest of justice dismissal with prejudice is legally required, as in inciting the RICO Act. It's everybody's job not to do this to you and see that nobody does this to you. But everybody's doing this to you. So no matter what court of law you go into, you want to kick down the doors, and make them eat each other up. They have to eat each other alive according to this, This is the law. A bunch of laws they threw together, all right? I use the rules of professional conduct to get them to do this quick, fast, in a hurry. I have meritorious claims and contentions. Reporting misconduct, where is it? I trust you will live up to the oath, penalties for violating the oath. And then I started throwing the rules of professional conduct. I trust you will show competence. This is the law. Rules of professional conduct are a list of laws in a court of law. I trust you will show competence, diligence, you know what that means, right? And if you want the legal definition, look up the rules of professional conduct, click on that, and it'll tell you. That means they got to do shit quick, fast, in a hurry, and they have a limited time to answer you. So this ain't going to take years, okay, if you say this. I trust you will live up to the oath, show competence, diligence, in expediting litigation. Yeah, that sounds pretty. It sounds like casual conversation, but I'm showing you these are laws I just threw together. As I have meritorious claims and contentions, that's Rule 3.1. You can't bring in any fraudulent or frivolous claims, otherwise it could be thrown out immediately. See, but that's what they did. They brought fraudulent and frivolous claims. So you have meritorious claims of contention showing that they were the ones that brought the fraudulent frivolous claims, okay? They're not supposed to do that. People do that, called slap suits. They threaten you with, suing you, and you got to get a lawyer, and the lawyer's not going to tell you, hey, they don't have any meritorious claims and contentions, so this can't proceed in a court of law. It's against the law to even do this. But, lawyers think in the terms of billable items, and doing their job would lack those billable items. I have meritorious claims of contention, so I strongly stress reporting professional misconduct. So that means they have to notify the inquiry board. They have to cite, all the judge, all the lawyers, anybody and everybody that was involved, the clerk's office, the clerk, the stenographer, they were all in on it, Okay, and maintaining the integrity of the profession. I copied and pasted that out of the preamble, that little line right there. All this is copy and paste. And I just put, I trust. So I'm saying, I know you will, because this is the law. I trust communications. That's Rule 1.4 in the Rule of Professional Conduct. That's a law. I trust communications will be made for ethical violations. So they're legally responsible for citing them for ethical violations. And if you don't bring it up, they won't do it. And every penalty will be imposed in the public interest. It's a legal mandate to do what's in the public interest. Our interest as trustees. It says that in the public trust doctrine, they are trustees of the public trust. So as trustees, this is how to maintain the public trust, because the court system is part of the public trust, your trust fund. A failure to do so would add to this conspiracy against rights under the color of law. And this is an interest of justice dismissal with prejudice is legally required. That's a law. Because they broke every law in the book to make you look guilty before anything even started. You see, everybody wants to talk about what they're going through. All they need to know is how everything was supposed to start. It didn't begin this way, and it won't end this way. Okay. So I explained to a gentleman, you literally have to have the legal knowledge, of a lawyer to get your effective assistance of counsel. He agreed. And he's having to defend himself in a pro se motion, which is ridiculous, because that's not a fair trial. You're forced to go pro se because the judge and the opposing party never cited your attorney for ineffective assistance of counsel. That's illegal. That's deprivation of rights. That's deprivation of effective assistance of counsel. No effective assistance of counsel, no fair trial, no due process. It's pretty easy to understand. Okay, so I just threw a bunch of laws together. It doesn't take that much to understand, okay? All you got to do is read it and hold me to the letter of the law on that, as I will you in every court of law. Okay, you do realize the penalties for violating the letter of the law pretty much are the same thing here, death penalty and all that, life imprisonment, and reimbursement. You got to reimburse for everybody for all their losses, and all kinds of good stuff, and it's citing the RICO Act. If you look up the RICO Act, it'll tell you you were hit worse than this is worse than the mob would do to you. But and then I talked to you about who's sworn to prosecute and sue on your behalf, and I went over that with you earlier. They took the oath, and the oath requires them to live up to their job descriptions. And when you go to the DOJ, and you click on a complaint, conspiracy against rights under color law complaint form, And they give you a list of places to go. You go to the DOJ. When you click on it, you scroll down, it says, we prosecute and sue on your behalf. People were asking me if I knew of a lawyer that would, sue on their behalf. Well, yeah, I know a bunch of them. It's their job. Specifically, that's their job, to sue for a conspiracy against rights under the color of law. And they work for the DOJ, the FBI, the Department of Homeland. There's a lot of them. There's a lot of government agencies that have civil rights divisions that will take care of this for you. Okay? But don't keep it a secret, Talk to your friends, families, neighbors. Get as many people involved as you can. And have them send in for you too, so they'll have to send them an answer as well. Remember, this is the law, they have to be diligent in expediting this litigation, and there's a time limit. So you should hear something in a matter of weeks, okay? And, you could slap that on a motion to quash as well, post-conviction. I put this on a late notice of appeal back in '91. Guy's lawyer didn't file in a timely manner and kept his money. So I put this on a late notice of appeal. He still had a couple weeks left. I think the time limit, the statute of limitations on that was 90 days. So he had 90 days or 120 days after his lawyer decided he wasn't going to do his job and keep the money. And this is it. Get out of jail free card. Get out of a lot of whatever, the young lady I'm talking to, she lost everything in divorce court, even lost on a divorce. Can't get her divorce. Judge says, no, you gotta stay married to this guy. And won't let her in the house. It was pre-planned. She had no idea. So I don't even want to go to what I suspect is happening in the background in his behalf. But I've seen this happen many times. I used to try to help people in divorce court when I was going through my divorce. And what happened afterwards, my ex didn't live up to our contractual obligations. It just took off. And there was nothing I could really do about it. Out of state, Now there's laws against doing stuff like that, but back then there wasn't. But see, they're telling her there's not too much she can do as far as divorce court. But see, there was a whole lot of laws broken in the court to do what they did to her. So she could use this to get back at the judge and all the lawyers involved. The judges, the lawyers. She's been before many judges, many lawyers. And this is what they did to her. They committed a conspiracy against rights under the color of law. See, so now she understands. Just filing deprivation of rights isn't going to just do it, because you can't just file deprivation. I mean, you can, and legally they're supposed to, hook your lawyer up and throw away the key and, take all his shit. And, if he's got, one of them cyber trucks or whatever, condo on the beach, that's yours. They'll say, oh, well, he got an LLC, but that's in the interest of the bar, not in the public interest. Okay, so clearly under the color of law. Okay? Just try to make things easy for you. When I talk, it's a lot of legal terms, so you can Google what I say. And remember, I strongly suggest you hold me to the letter of the law as I will you in every court of law, any court of law. Look up the penalties for violating the letter of the law. Violating the letter of the law is distributing disinformation. Look up penalties for disinformation. Okay, but nothing but peace and love to you. Remember, you don't have to go to my page. I just went for mine because it was a matter of convenience. I do this page, Legal Reform, Community Service. Okay, so that's where I left that. You'll find it here somewhere. Sometimes people ask me questions or I find them on the internet, and to disrupt all the disinformation. I know people don't like fact checkers. Oh, here it is. Oh, this is the long version. See, what I gave you to put was just up here. Right up to here. And that little bit up there explains all the laws they broke down here. Okay. So if you want to understand all the laws they were breaking, the judge not reporting misconduct, that's misconduct. So that's what I put there, When I wanted to talk to the judge, they made sure I didn't come out there and made me walk the Green Mile. I was violating Rule 2.6, ensuring the right to be heard. Judge shall perform the duties of judicial office impartially, competently, and diligently. Rule 2.15, responding to judicial and lawyer misconduct. That's what my lawyer, said the quiet part out loud. So he went and told the judge that I was going to report him for misconduct, her for misconduct, the state's attorney for prosecutorial misconduct. I didn't get a chance to say all that, but just saying that, reporting misconduct is mandatory in both the rules of professional conduct and the code of judicial conduct he took off. And so at that point, I'm pretty sure he recognized the fact that I knew the rest of this. Responding to lawyer and judicial misconduct, a judge knowing that another judge has committed a violation of this code that raises a substantial question regarding the judge's honesty, trustworthiness, or fitness as a judge in all respects shall inform the Illinois Judicial Inquiry Board. Another judge, judge knowing that a lawyer has committed a violation of the rules of professional conduct that raises a substantial question regarding a lawyer's honesty and trustworthiness. So my lawyer, all the lawyers that worked in this case, not just on my side, but in the opposing party, we had a lot of state's attorneys go through, and the judges, because it went to appellate court and they just rubber stamped it. So they added to this conspiracy against rights under the color of law. Judge knowing that another judge has committed a violation. Okay. So, it's impossible if the judge doesn't cite your attorney or the opposing party for the violations in the rules of professional conduct, all those counts of misconduct, the judge is committing misconduct. So when they violate that one canon, they wind up violating all this other stuff. Compliance with the law. A judge shall comply with the law, including the code. The code requires reporting a lawyer's misconduct, promoting confidence in the judiciary. Judge shall act at all times in a manner that promotes public confidence in the independence, integrity, and impartiality of the judiciary, and shall avoid impropriety and the appearance of impropriety. I mean, to you, they always showing the impropriety, but I'm showing the laws to use against them for those improprieties, okay? Rule 1.3, avoiding misuse of the prestige of judicial office. Well, thus far they haven't done anything else that I just mentioned, so that's misuse of the prestige of the judicial office. Okay, office to advance the personal or economic interests of a judge or others, or allow others to do so. Okay, which, they do for politicians and rich people. That's why I keep telling you we're living in a corporacy. We're living under corporate rule. And that's why we're living under the color of law, because we're living under corporate rule. A corporacy. Layman's terms is called a corporacy, but it's actually corporacy. That's a Greek term, combination of corporation and government. A corporacy, a corporation of government, basically a government that sets up for to rule on benefit the corporations like we're doing now. Impartiality and fairness, the judge shall uphold and apply the law. And I just seen some crazy judge decide the jury found some guy guilty for embezzlement, fraud, all this other stuff, and the judge says, "Nah, well, I don't like your decision, so I'm gonna change it and find him not guilty and let him go." What? A lot of people are pissed about that. A judge shall not, in the performance of judicial duty by words or contact, manifest bias or prejudice, or engage in harassment, including but not limited to bias, prejudice, harassment based upon race, sex, gender identity, religion, national origin, ethnicity, pregnancy, disability. You can see right now nobody gives a fuck about that. Supreme Court just ruled that ain't nobody got to do that. How can you do that? No, that's not in the public interest. This is in the public interest. That's why it was written. Age, sexual orientation, marital status, people are getting fired because of their political affiliations. And shall not permit court staff, court officials, or others subject to the judge's direction and control to do so. So they're not supposed to let anybody in that courtroom screw with the law. And hold them to the letter of the law on all these people, seriously. Otherwise they're going to tell you, well, that's not how we interpret that. They always say that's stupid. That's not. No, if that's not how you interpret that, that's violating the letter of the law. You even try telling me it means something other than what it says, you can be charged with disinformation. There's penalties for that as well. The restrictions, okay, a judge shall not retaliate against those who report violations. Everybody I talk to about reporting violations have been retaliated against. Mostly just in the courts. But sometimes you'll find people behind the badge visiting you to intimidate you, to get you to stop what you're doing. That's against the law. That's part of the conspiracy against rights under the color of law. Okay, external influence on judicial conduct. Competence, diligence, and cooperation. If they're not doing all the other stuff, that's not competent. Diligent. That's why I always tell you people, if you don't ask for a quick and speedy trial, because the judge is required to be diligent with the proceedings in the court. not to waste time, not to procrastinate, not to let the lawyers procrastinate. Procrastination is forbidden in the rules of professional conduct as well as in the code of judicial conduct. It's in the preambles. So, but if you let them not do this, if you don't say, hey, this is the code of judicial conduct, and it says this is what you got, they're not going to do any of this. They're not. And if you've been in a court of law, you probably know they ain't done none of this already. See, I'm going to bypass reading it because you can come by and read it yourself or take it and share it to your wall or whatever, and read it yourself. But see, all this is not happening. So by not reporting misconduct, they violated all this. See, decorum, demeanor, and communication with jurors. So that judge I was talking about that threw out the jury's decision, well, he's going to hold the jury to this, but decorum, demeanor, he's going to. But the judge isn't going to do it themselves. A judge shall be patient, dignified, courteous to litigants, jurors, witnesses, lawyers, court staff, court officials, and others with whom the judge deals with in official capacity. And that includes pro se litigants. And if they were to treat them fairly, the pro se litigants, they wouldn't be holding to all the legal obligations of legal learned professionals, lawyers, and judges. I'd say, that's not a fair trial. You got to learn this shit on the way. I'm just trying to make it easy for you and let you know that, you're getting screwed. A judge shall disqualify himself or herself in any proceeding which a judge impartiality might reasonably be questionable. Well, if you're not going to live up to the rule of professional conduct, step the fuck down. Or the code of judicial conduct and the rule. If you're not going to live up to your oath, you're not fit for the bench. You're not fit for a license to practice law. I wouldn't give you a license to practice tiddlywinks. You're not doing your job. Your job. Supervisors do there's a lot, you can cite them for simply for not citing your lawyer for ineffective assistance of counsel. Okay, so I think I've been on this long enough, this video. Okay, and then they got to cite the lawyer for everything they didn't do. So that's where I threw Illinois Rules of Professional Conduct. So they're supposed to report your lawyer for not doing all of this. Okay, they ain't do none of this. Okay. Okay, this is a preamble. Reads like a Boy Scout, Girl Scout, whatever, handbook, honesty, trustworthiness, loyalty, to the oath. And everybody that I've talked to, it took them a while, but they eventually understand the only loyalty they have is to each other. They may have taken the oath, but they're not living up to it. You know what the penalties are for violating the oath alone? And these are the mandatories of that oath. Many of a lawyer's professional responsibilities are prescribed in the rules of professional conduct as well as substantial and procedural law. However, a lawyer is also guided by personal conscience and by professional peers. A lawyer should abstain the highest level of skill to improve the law and legal profession and to exemplify the legal profession's ideals of public service. No matter what you go through, it's going to keep reminding the lawyers that they are public servants. They are there to serve the public. Okay, remember, the oath comes first. The oath comes first. Doesn't matter who they work for. I don't care if they work for, a politician, the CIA, the FBI, the DEA, Toyota, Ford, Mitsubishi. In order for a lawyer to practice law in the United States of America and its territories, they're legally obligated to abide by the oath, uphold that oath. The oath always comes first. And that oath they took is no different from our Pledge of Allegiance to we the people. Except for you can hold them legally accountable for violating that oath. The young lady was talking to me about the lawyer's confidence. The lawyer can be sure that preserving a client's confidence originally serves the public interest. And I kept mentioning to her the public interest. That's a mighty strong legal term for a law. Everybody, all lawyers say, says they got to do everything that is in the public interest. They know that their communications will be private. She can prove that her communications with her lawyers did not remain private, that he shared them. And I told her, yeah, because they're working together against you. It's already been decided. And they're getting pissed because you keep fighting back. But she's using that statement I gave, that tells you that they ain't doing all of this. It's a lot of stuff they're supposed to be doing and they ain't doing. Is an important force. Self-regulation helps maintain the legal profession's independence from government domination. Independent legal profession is an important force in preserving government under law. For abuse of legal authority is more readily challenged by a profession whose members are not dependent on government for right to practice. Profession has a responsibility to ensure that its regulations are conceived in the public interest, not in furtherance of parochial or self-interest concerns of the bar. How many times did I mention that in all my other videos? It's law. Okay? It's regulations, laws are conceived in the public interest, in your interest, and not furtherance of parochial, like religions, or self-interest, meaning personal gain, or concerns of the bar. What's best for their brethren, the legal community. Keep telling you people, it's a society within a society. The only way you can stop them is use the laws. Use law. I'm showing you, use law. And you got to be up front and take it to them. Take every avenue, every route. Who's professional conduct are rules of reason. They should be interpreted with reference to the purpose of legal representation in the law itself. Someone whose imperative cast in the terms shall or shall not. These define proper conduct for purposes of. Okay, so you can, all that you can use against these knuckleheads. Okay, now these are the rules. Competence. I tell people, see, even if they violate one rule, they wind up violating others. Okay, one must be competent. And doing all this would be showing that competence. One must be diligent. That would be competent, to be diligent. Communication. One must be diligent in communication. That would be competent. Confidentiality of information. It will be diligent to communicate the confidentiality of information. Safekeeping property. All y'all have been in conservatorship, guardianship, probate. They don't, that's not safekeeping property. And seriously, probate court, come on now, they don't do none of this, all right? So that's where you want to start if you're like in probate, safekeeping property. Look that up, okay? So even though if you're out pro se, you don't have any representation. Remember, in fairness to the opposing party, Rule 3.4, fairness to the opposing party and counsel, since you don't have counsel, fairness to the opposing party, it will be diligent to communicate, where is it? An expediting litigation, because they won't give you anything. Nobody will let you know what's going on. The papers that are filed, nothing that you can research. So expediting litigation, Rule 3.2, assures that you will have that litigation, everything. Whatever they have, whatever they're using against you, they have to give it to you. They can't say, been told many times, I'll wait till you get a lawyer. You need to get a lawyer. No, I filed on a pro se motion, and legally you have to, and then I pull out the rules of professional conduct and I go over it. And they just hand it over. But if I didn't have it, and that's how they would tell me, and then I would be stuck trying to find a lawyer that's going to live up to the rules of professional conduct, what the oath requires them to do. This is the oath. This is behind the oath. Then I told you reporting professional misconduct, reporting professional misconduct. It's mandatory. I used to say reporting professional misconduct is mandatory. But I've been throwing this around since 1979, so they keep changing the language and moving things around. But not doing any of this, that's misconduct. So you got multiple counts of misconduct if the judge didn't report, opposing party didn't report, your lawyer didn't even, your lawyer's not going to report himself for not doing his job. Come on, people, give me a break. Quit getting mad at me because of this conspiracy to deprive you of your constitutional rights under the court of law and every court of law. I can't stop it, but you can with the information that I'm giving you. You can if I could, I'm not a lawyer. My academic credentials don't see that of a GED. And I've been talking like this for 50 years. For those that would listen, back then everybody used to think I was nuts. But I wasn't even old enough to graduate high school. But, when I was 10 and read about this thing, due process, in our beloved United States Constitution, I had to find out what it was. And I did. And I've been trying my hardest to do something about it, and using the law. But who's going to do something about it? Nobody. But if I can get you all to live up to that Pledge of Allegiance, it wasn't just to a flag, it was to what that flag represents. The Declaration of Independence and the fruits of its labor, our beloved United States Constitution, the law of the land. In a nation of laws, I implore you to confront everybody in the judicial system with this conspiracy against rights under the law, under the color of law complaint. Anybody can use this in any court of law. No matter what law, as long as it's in the United States and its territories, or as some people call it, our colonies, our colonies. And even our colonies, the Constitution doesn't apply there. That's why Cuba revolted. That's why Vietnam revolted. They wanted a Constitution like we have a Constitution. Our government said, hell no. We let you be a democracy. We can't pillage your public trust. If we're a democracy, we have to respect the public trust doctrine. Can't do that. So it was just to prevent, democracy elsewhere. Because the same laws that apply to us would apply to them. That whole DEI thing where it says, we are endowed by our Creator with certain inalienable rights. Amongst these are life, liberty, and pursuit of happiness. Specifically, he says, we are endowed by our Creator. Now that's for we, the people, every United States citizen. So say that to yourself. I am endowed by my Creator with certain inalienable rights. Amongst these are life, liberty, and pursuit of happiness. This is my birthright as a U.S. citizen. These are my constitutional rights. This is the Bill of Rights. These are, as a human, my rights. All right, people. Remember, this is a little bit. This little bit right down to there explains all that other stuff. What they didn't do. I just abbreviated it. Any judge, any lawyer would understand it, and it would piss them off. I've been known to piss off many. And I would always question their competence. If you're not competent, that makes you what? If you're not competent, that makes you what? And people would be looking at me. That makes you incompetent, right? And I look at people, right. But see, I would be amongst laymen with a couple attorneys, and they would just turn around and run. And people would say, they would get mad, but see, I wasn't making just a joke. I was stating the law. But see, it's I have an adverse sense of humor when it comes to citing the law, and I like to use layman's terms, like I did here. Okay, everything you can look, you'll understand. You can understand it. Layman's terms. That's how it was written. I just copied and pasted a lot of stuff together right here. That's all. That's all it is. All right, a lot of copy and paste. Call it plagiarism because I didn't write it. I plagiarized it. It's just a combination of laws. That's all. All right, and it's for you. Okay, I don't charge nothing for what I do. It's a nonprofit. I've always been a charitable person. You know, it's just a promise I made. You know, to leave this world a better place than when I came, from when I entered. That way, upon the ascension, when I get asked, what did you do? What did you do while you was down there? You know, when I get there, all I'm going to get is a pat on the back. And hopefully, here, nice job, son, nice job. Hopefully. That's what I'm working on. I've been questioned a lot of times, who are you trying to impress? The Almighty. The Almighty. All right, so, you know, for the spiritual, religious, I'm a Christian. Every day I wake, regardless of what I feel, what I thought, I ask myself, what would Jesus do, and proceed accordingly. And that's all I'm doing. I mean, as a Christian, you don't have to be a Christian, but uh, you know, most religions, religious people I've talked to of other religions, have talked about similar things, that I do. Preservation of love, preservation of life. Love thy neighbor. Quality under. Different religions, but same contact. Same contact. All right, so. As he commands, love thy neighbor. Just trying to show some love, people. All right, you have a good night. May your Creator always be with you. May you have a long life and good health. I wish you nothing but peace and happiness. Good night.